Question 1. A notary public in New York is presented with a document written entirely in Spanish by a signer who does not speak English. The notary public does not understand Spanish but believes the signer understands the document. What is the appropriate action for the notary public to take? A. Proceed with the notarization, as the signer indicated understanding. B. Decline the notarization, as the notary public cannot confirm comprehension of the document's content. C. Ask the signer to obtain an official translation of the document before notarizing. D. Request the signer to bring a translator who can certify the translation's accuracy. Answer: B. Decline the notarization, as the notary public cannot confirm comprehension of the document's content. A New York notary public must be able to communicate effectively with the signer to ensure they understand the nature and purpose of the document being notarized. If a notary cannot read the document's language and cannot communicate with the signer, they cannot fulfill their duty to confirm the signer's comprehension or willingness to sign. Proceeding would violate the notary's impartiality and duty to prevent fraud, as they cannot verify the signer is acting knowingly and voluntarily. Always remember, if you cannot bridge the language barrier to confirm understanding, you must decline the service. Question 2. A notary public's commission in New York expires on June 30, 2024. The notary submits their renewal application to the Department of State on June 15, 2024. Can the notary public continue to perform notarial acts after June 30, 2024, while awaiting the processing of their renewal? A. Yes, provided the renewal application was submitted before the expiration date. B. No, the commission expires on June 30, 2024, and acts cannot be performed until the new commission is received. C. Yes, but only for a grace period of 30 days after the expiration date. D. No, unless they receive a temporary extension from the Department of State. Answer: B. No, the commission expires on June 30, 2024, and acts cannot be performed until the new commission is received. In New York, a notary public's commission expires on the date printed on their commission certificate, regardless of when a renewal application is submitted. There is no grace period for performing notarial acts after the expiration date. Performing acts with an expired commission is unauthorized and can lead to serious penalties, as the notary lacks the legal authority. Always be diligent about your commission's expiration date and wait for your renewed certificate before resuming notarial services. Question 3. A notary public is asked to notarize a document by their spouse, who is also the grantor in the transaction. The notary public is not a party to the instrument and will not receive any direct financial benefit from the transaction beyond what their spouse receives. Can the notary public lawfully notarize the document for their spouse in New York? A. Yes, because the notary public is not a direct party to the instrument and has no direct financial interest. B. No, a notary public may not notarize for their spouse due to potential indirect interest and conflict of interest. C. Yes, provided the document is not related to a real estate transaction. D. No, unless the notary public discloses the relationship on the notarial certificate. Answer: B. No, a notary public may not notarize for their spouse due to potential indirect interest and conflict of interest. A New York notary public is prohibited from performing notarial acts for their spouse, even if they claim no direct financial interest in the transaction. The law views a spouse's interest as the notary's indirect interest, which compromises the notary's required impartiality. Performing such an act would create a conflict of interest, potentially invalidating the notarization and leading to disciplinary action. Always decline a notarial act when there is any direct or indirect personal or financial interest, including for close relatives like a spouse. Question 4. A New York notary public is asked to administer an oath to a witness who will testify remotely via video conference in a legal proceeding. The witness is physically located in another state. Can the New York notary public lawfully administer this oath? A. Yes, because the notary public's jurisdiction extends statewide for administering oaths. B. No, a New York Notary Public's jurisdiction is limited to the physical borders of New York State. C. Yes, provided the Notary Public can visually identify the witness through the video conference. D. No, unless the remote proceeding is explicitly authorized by a New York court. Answer. B. No, a New York Notary Public's jurisdiction is limited to the physical borders of New York State. In New York, a Notary Public's authority to perform notarial acts is strictly limited to the geographical boundaries of New York State. For an oath or affirmation to be validly administered by a New York notary, the signer, deponent, must be physically present within New York State at the time of the notarization. The fact that the proceeding originates in New York or is for a New York court does not extend the notary's physical jurisdiction. This means a New York notary cannot administer an oath to someone physically located in another state, even if using remote technology. Question 5. A notary public in New York receives a document requiring a certified copy. The document is a personal will. What action should the notary public take? A. Make a photocopy of the will and attach a notarial certificate stating it is a true copy. B. Decline to certify the copy, as New York notaries public are generally prohibited from certifying copies of documents. C. Refer the signer to the county clerk or the document's issuing agency for a certified copy. D. Certify the copy only if the signer presents the original document to the notary public. Answer. B. Decline to certify the copy, as New York notaries public are generally prohibited from certifying copies of documents. In New York, a notary public's authority does not include the power to make or certify true copies of documents. This power is typically reserved for the custodian of the original record or the issuing agency, such as a county clerk's office for public records. The only exception to this general rule is for the protest of a negotiable instrument, which is a specific, limited power. Therefore, a New York notary cannot certify a copy of a personal will or most other documents. Question 6. A notary public is approached by a signer who requires a document to be notarized, but the signer only has an expired driver's license as identification. The notary public personally knows the signer very well. What is the appropriate action for the notary public to take? A. Proceed with the notarization, as personal knowledge of the signer is sufficient. B. Decline the notarization because the identification is expired. C. Proceed with the notarization, but make a note in a personal journal about the expired ID. D. Ask the signer for a secondary form of identification, even if expired. Answer. A. Proceed with the notarization, as personal knowledge of the signer is sufficient. In New York, personal knowledge of the signer is a valid and acceptable method for a notary public to identify an individual. If a notary public has known the signer for a sufficient period to be certain of their identity and believes they are who they claim to be, the notary may proceed with the notarization without requiring other forms of identification. This differs from many other states that may require specific forms of unexpired government-issued ID. Your personal knowledge serves as reliable evidence of identity in New York. Question 7. A deed was signed by a grantor, the person conveying property, in the presence of a subscribing witness, but not in the presence of a notary public. The grantor is now unavailable. The subscribing witness appears before a notary public and wishes to legally prove the grantor's signature on the deed for recording purposes. What notarial act would the notary public perform for the subscribing witness in New York? A. An acknowledgement of the subscribing witness's own signature. B. A jurat, where the subscribing witness swears to the truth of the deed's contents. C. A proof by subscribing witness, where the witness attests to witnessing the grantor's signature. D. Decline the notarization, as the grantor was not personally present before the notary. Answer. C. A proof by subscribing witness, where the witness attests to witnessing the grantor's signature. In New York, a notary public can perform a specific act called proof by subscribing witness. This act is used when the original signer of a document, such as a deed, cannot personally appear before the notary for an acknowledgement. Instead, a subscribing witness, who was present when the original signer signed the document, appears before the notary and attests under oath or affirmation that they witnessed the original signer execute the document. This unique notarial act allows the document to be legally proven for recording purposes, even without the original signer's direct appearance. Always remember, this specific New York power is for proving another's signature through a witness, not for notarizing the signer's own acknowledgement directly. Question 8. A notary public receives a document to be notarized and notices that the notarial certificate wording is for an acknowledgement, but the signer needs to swear or affirm to the contents of the document. What should the notary public do? A. Proceed with the acknowledgement, as the signer signed in front of the notary. B. Attach a separate jurat certificate or strike out the acknowledgement wording and replace it with jurat wording, ensuring the signer swears or affirms. C. Inform the signer that the document requires a different notary service. D. Advise the signer to obtain a new document with the correct notarial wording. Answer: B. Attach a separate jurat certificate or strike out the acknowledgement wording and replace it with jurat wording, ensuring the signer swears or affirms. A notary public must ensure that the notarial act performed matches the signer's intent and the document's requirements. If a document has an acknowledgement certificate but the signer needs to swear or affirm, indicating a jurat, the notary must correct the certificate. This can be done by crossing out the incorrect wording and writing in the correct jurat wording, or by attaching a separate jurat certificate, provided the signer signs or re-signs in the notary's presence after taking the oath/affirmation. It is the notary's duty to complete the proper notarial certificate to reflect the act performed. Question 9. A notary public is found guilty of a misdemeanor offense in New York. Which of the following is true regarding the impact of this conviction on the notary public commission? A. The commission is immediately revoked upon conviction. B. The Department of State must be notified, and they may take disciplinary action, but revocation is not automatic. C. The commission is unaffected, as only felony convictions lead to revocation. D. The notary public must resign their commission within 30 days of conviction. Answer: B. The Department of State must be notified, and they may take disciplinary action, but revocation is not automatic. While a felony conviction automatically disqualifies a person from being a New York notary public and generally leads to immediate revocation of an existing commission, a misdemeanor conviction does not result in automatic revocation. However, the Department of State, which oversees notary commissions, has the authority to review misdemeanor convictions and may choose to suspend, revoke, or refuse to renew a commission based on the nature of the offense and its relevance to the notary's duties. It is important to notify the Department of State of any conviction, as failing to do so could also lead to disciplinary action. Question 10. A person desires to become a notary public in New York. Which of the following is a mandatory qualification? A. Must be a resident of New York State for at least 1 year prior to application. B. Must be at least 21 years of age. C. Must be a United States citizen. D. Must be a resident or have a place of business in New York State. Answer: D. Must be a resident or have a place of business in New York State. To qualify as a notary public in New York, an individual must either be a resident of the state or maintain a place of business within the state of New York. There is no specific 1-year residency requirement. The age requirement is typically 18 years old, and U.S. citizenship is not a mandatory qualification, though the individual must be legally present and authorized to work in the U.S. This flexibility allows individuals who commute into New York for work to serve as notaries. Question 11. A notary public performs a notarial act for a fee. Which of the following is required for the notary public regarding this fee in New York? A. The notary public must issue a written receipt for every fee collected. B. The notary public must maintain a log of all fees collected in their journal. C. The notary public is not required to provide a receipt unless requested by the signer. D. The notary public must display a schedule of fees in a prominent location. Answer: C. The notary public is not required to provide a receipt unless requested by the signer. In New York, a notary public is not generally required to issue a written receipt for every fee collected for notarial services, nor is there a specific mandate to log fees in a journal, though maintaining a journal is highly recommended for best practices. However, if a signer requests a receipt for the fee paid, the notary public must provide one. This requirement ensures transparency and accountability when requested by the public. Question 12. A notary public is asked to take the acknowledgement of a deed. The signer arrives at the notary's office without identification, stating they left their wallet at home. The notary has never met the signer before. What should the notary do? A. Refuse to perform the acknowledgement. B. Perform the acknowledgement, but make a note in their personal record about the lack of ID. C. Ask the signer to return later with proper identification. D. Suggest that the signer bring a credible witness who the notary also knows. Answer: A. Refuse to perform the acknowledgement. If a notary public does not personally know the signer and the signer lacks satisfactory evidence of identity, the notary must refuse to perform the notarial act. Unlike some states that allow credible identifying witnesses, New York notary law primarily relies on the notary's personal knowledge or reliable documentary identification. To proceed without proper identification would be a significant breach of duty and could lead to disciplinary action. The notary cannot simply make a note or rely on a credible witness system not outlined in New York law for identification purposes. Question 13. A New York notary public is also an attorney. In a real estate transaction, the attorney-notary drafts a deed for a client and then is asked by the same client to notarize the client's signature on that deed. Can the attorney-notary lawfully perform this notarial act? A. Yes, because the notary public is an attorney acting in a professional capacity. B. No, because it creates an inherent conflict of interest for the attorney-notary. C. Yes, provided the attorney-notary does not charge a separate notarial fee. D. No, unless the client signs the deed in the presence of another notary. Answer: B. No, because it creates an inherent conflict of interest for the attorney-notary. A notary public in New York, even if also an attorney, generally cannot notarize a document that they have prepared for a client or in which they have a direct or indirect interest. Drafting the deed for the client creates a direct interest in the transaction, compromising the notary's impartiality and independent role. The purpose of a notarization is to provide an unbiased verification of a signature or oath, which is difficult to maintain when also serving as the legal representative who prepared the document. Always separate your roles as attorney and notary to maintain impartiality. Question 14. A New York notary public changes their business address within the same county. What action, if any, is required concerning their notary commission? A. No action is required, as the commission is county-specific. B. The notary public must notify the Department of State of the address change within 10 days. C. The notary public must file a new oath of office with the county clerk. D. The notary public must notify the Department of State of the change upon renewal of their commission. Answer: B. The notary public must notify the Department of State of the address change within 10 days. In New York, notaries public are required to notify the Department of State of any change in their residence or business address. This notification must be submitted within 10 days of the change. This ensures that the Department of State has accurate and up-to-date contact information for all commissioned notaries. Failing to promptly update this information can lead to administrative issues or disciplinary action. Question 15. A notary public is presented with a document signed by an individual who is physically unable to sign due to a temporary medical condition. The signer directs another person, who is present, to sign on their behalf. Can the notary public lawfully notarize this signature in New York? A. Yes, the notary public can notarize the mark of the physically impaired signer, witnessed by the other person. B. No, the signer must physically sign the document themselves for it to be notarized. C. Yes, provided the person signing on behalf of the impaired individual signs their own name and the impaired individual is present and assents. D. Yes, if the impaired individual makes an X mark and the notary public writes their name next to the mark, and then notarizes. Answer. A. Yes, the notary public can notarize the mark of the physically impaired signer, witnessed by the other person. In New York, if a signer is physically unable to sign their name, they can make a mark, such as an X, on the document, and the notary public can notarize that mark. It is good practice for the notary to write the signer's name next to the mark and note that the mark was made by the signer. This practice is akin to notarizing a regular signature and ensures that individuals with physical limitations can still execute documents. The key is that the act of signing, even by mark, is performed by or at the express direction of the individual whose signature is being notarized. Question 16. What is the primary purpose of a jurat notarial act? A. To certify that a document is a true copy of an original. B. To verify the identity of the signer and acknowledge their signature. C. To swear or affirm that the contents of a document are true and accurate. D. To attest to the signing of a document in the notary's presence by a credible witness. Answer. C. To swear or affirm that the contents of a document are true and accurate. A jurat is a notarial act where the signer, in the notary public's presence, signs the document and then takes an oath or affirmation swearing or affirming that the statements contained within the document are true. This act typically involves the phrase, subscribed and sworn to before me, and is common for affidavits, depositions, and sworn statements. The core concept is verifying the truthfulness of the document's content, rather than just the authenticity of the signature. Question 17. A notary public advertises their services. Which of the following is prohibited in New York State for a notary public to include in their advertisement? A. Stating notario publico without clarifying their official title in English. B. Listing their fees for notarial services. C. Including their commission expiration date. D. Advertising mobile notary services. Answer. A. Stating notario publico without clarifying their official title in English. In New York, a notary public is strictly prohibited from using the term notario publico in any advertisement or representation without also clearly stating in English that they are a notary public and not an attorney authorized to practice law. This rule exists to prevent confusion, especially among Spanish-speaking individuals, who might mistake a notario publico for a legal professional with powers similar to lawyers in some Latin American countries. This helps prevent the unauthorized practice of law and protects the public. Question 18. A notary public performs a notarial act for a close friend. The friend offers the notary $20 for a service that has a maximum statutory fee of $2. What should the notary public do? A. Accept the $20, as it's a gift from a friend. B. Accept only the statutory fee of $2. C. Decline any payment, as it's a friend. D. Accept the $20, but inform the friend that the usual fee is $2. Answer. B. Accept only the statutory fee of $2. A notary public in New York must never charge more than the maximum fee prescribed by law, regardless of the circumstances or the relationship with the signer. Accepting $20 for a service with a $2 maximum fee, even as a gift or from a friend, constitutes overcharging and is a violation of the notary's duties. Adhering to the statutory fee limits protects both the public and the notary from potential disciplinary action. Always stick to the official fee schedule to maintain compliance and professionalism. Question 19. A notary public discovers that their commission has expired 1 week ago. They have performed several notarizations since the expiration date. What is the most appropriate action for the notary public to take regarding these past notarizations? A. Contact all signers and re-notarize their documents with a valid commission. B. Assume the notarizations are valid if no one complains. C. Immediately cease all notarial acts and apply for a new commission, but the past acts performed while expired are invalid. D. Notify the Department of State and request a retroactive validation of the past notarizations. Answer: C. Immediately cease all notarial acts and apply for a new commission, but the past acts performed while expired are invalid. Notarial acts performed by an individual whose commission has expired are invalid, as the individual lacked the legal authority to act as a notary public. The most crucial immediate step is to cease all notarial activities. There is no provision for retroactive validation of acts performed by an expired notary. While informing the signers might be a practical ethical consideration, the legal fact is that those acts are void, and the notary should focus on rectifying their commission status. Question 20. What specific power does a New York Notary Public have that is not commonly granted to notaries in many other U.S. states? A. The power to administer oaths and affirmations. B. The power to take acknowledgements. C. The power to protest negotiable instruments. D. The power to certify copies of public records. Answer: C. The power to protest negotiable instruments. One of the distinct powers granted to a New York Notary Public, which is less common for notaries in many other states, is the power to protest negotiable instruments. This involves formally declaring non-payment or non-acceptance of a financial instrument like a check or promissory note, typically for legal purposes. While administering oaths and taking acknowledgements are standard notary powers nationwide, the power to protest negotiable instruments is a specific, unique authority within the New York Notary Statute. Question 21. A notary public's commission is issued by which New York State Department? A. Department of Motor Vehicles. B. Department of State. C. Department of Justice. D. Department of Financial Services. Answer: B. Department of State. In New York, the licensing and oversight of notaries public fall under the jurisdiction of the Department of State. This department is responsible for processing applications, issuing commissions, maintaining notary records, and handling disciplinary actions. Therefore, all official communications regarding a notary's commission, including renewals and address changes, are directed to the New York Department of State. Question 22. When taking an acknowledgement in New York, the signer must: A. Sign the document in the notary public's presence. B. Acknowledge their signature before the notary public, but the signing itself could have occurred previously. C. Provide two forms of government-issued identification. D. Swear to the truthfulness of the document's contents. Answer: B. Acknowledge their signature before the notary public, but the signing itself could have occurred previously. For an acknowledgement in New York, the crucial element is that the signer personally appears before the notary public and acknowledges, declares, that they signed the document. It is not strictly required that the signature itself be affixed in the notary's presence, only that the signer confirms it is their signature. This differs from a jurat, where the signature must always be witnessed by the notary after an oath or affirmation. An acknowledgement verifies the signer's identity and their free will in signing, not necessarily the act of signing itself. Question 23. A notary public moves their residence from Kings County to Nassau County within New York State. What is required for their notary commission? A. The notary public must reapply for a new commission in Nassau County. B. The notary public must notify the Department of State of the address change and then file a certificate of official character with the Nassau County Clerk. C. The notary public's commission is automatically updated as it is statewide. D. The notary public must only notify the Kings County Clerk of their move. Answer: B. The notary public must notify the Department of State of the address change and then file a certificate of official character with the Nassau County Clerk. While a New York Notary Public's commission is statewide, meaning they can perform acts anywhere in New York, a change in their county of residence or principal place of business requires specific action. The notary must first notify the Department of State of the address change. Additionally, to perform acts and have their signature recognized in a new county of residence, it is essential to file a certificate of official character with the county clerk of that new county. This certificate confirms the notary's commission and allows them to file their signature with that county. Question 24. A notary public is asked to notarize an affidavit. The signer appears before the notary but states they are uncomfortable taking a religious oath. What alternative should the notary public offer? A. Refuse to notarize unless a religious oath is taken. B. Offer the signer an affirmation instead of an oath. C. Advise the signer to find a notary who is willing to administer a non-religious oath. D. Proceed with the notarization without requiring any form of solemn declaration. Answer: B. Offer the signer an affirmation instead of an oath. An affirmation is a solemn declaration that is legally equivalent to an oath but does not involve a religious reference or appeal to a deity. If a signer expresses discomfort with taking a religious oath, a notary public should offer an affirmation as an alternative. This ensures that the signer's conscience is respected while still fulfilling the legal requirement for a solemn declaration of truthfulness. Notaries must be prepared to administer both oaths and affirmations. Question 25. What is the term for the written declaration by a notary public attached to a document, certifying the performance of a notarial act? A. Affidavit. B. Attestation. C. Certificate of Notary Public. D. Notarial certificate. Answer: D. Notarial certificate. The notarial certificate is the official written statement completed by the notary public, appended to or included within a document, that formally certifies the performance of a specific notarial act. This certificate details essential information such as the type of act performed, e.g., acknowledgement, jurat, the date and place of the act, the names of the signers, and the notary's signature and stamp. It is the tangible proof that a notarial act has occurred and is the most crucial part of the notarization process.